Hello everyone. Good evening, good morning, good afternoon, depending on where you are in the world. I am attorney Yael immigration attorney here in Orange County, California, which is Southern California. For those of you that don't know the area, we're located between Los Angeles and San Diego, kind of in the middle. And we help clients from all over the world, throughout the United States and all over the world with their immigration cases. And every Thursday, I come on live here on Facebook and on YouTube, and I answer immigration questions. We received some questions during the week that I kind of put aside, and I picked the questions that I think are the most interesting for everyone. So if you're here, welcome. It's so good to see you. Please feel free to write your questions in the comments, and I will promise to try to get to them as we go. And if you're new here, please like us on Facebook, subscribe to our channel on YouTube so that you can get a lot more information about everything immigration and get invitations and notifications about these kind of events. So we do a live show every Thursday evening, 5:30 Pacific. Hello, good afternoon, Lilybeth. Thank you for joining. Thank you for being here. Like I said, I'm Yael. I'm an immigration attorney, and our firm here, Brudner Law, we only practice immigration law. So we don't take any other cases. We practice exclusively immigration law. And we received a lot of good questions. I'm going to answer them shortly. Just a general kind of notification to let you guys know that anything that I answer today is not legal advice. If you have a specific question that you want to know about your specific case, feel free to reach out to us, schedule a consultation, and that way I can review your case and give you your specific advice. But what we're talking about today is just general advice. It's not legal advice, okay? Because we're only answering generally, not to a specific situation. Perfect. Are you guys ready to answer some questions today? Okay, I am. Okay, let's jump into some of these questions. Again, if you are watching us and you want to ask a question about your immigration case, just feel free to write those questions in the comments. Okay, so question number one, I have an adjustment of status pending. When is it safe for me to travel? Well, this is a great question. Adjustment of status, for those of you that don't know, is just a fancy way to say a green card application, right? It's just a fancy way to say filing for your green card in the United States. So if someone says that they have an adjustment of status pending, I already know that they're filing for their green card and they're filing for it here in the US. And they want to know, this person wants to know, when is it safe to travel? The reason that they're even asking this question is if you travel when you have a pending adjustment of status case or a green card application, then immigration will actually deny your case unless you've reached a certain milestone in your case, right? So if you leave without reaching a milestone, a specific milestone, then immigration is going to think that you abandoned your case and you're not interested in applying and will generally deny your case. There's some exceptions. If you're on an H or an L visa, those are dual intent visas, not necessarily your case would be denied, but generally for most people, yes. So when is it safe to travel? It's safe to travel when you receive a travel document. Okay, if you filed for your green card and you ask for a travel document, then you can travel when you receive this travel document. Now, I honestly advise our clients, if you can stay here, not travel, then that's better. But if you need to travel, if there's any reason or any emergency or any, you want to travel, you want to leave, you can go for a short trip and come back when you get your travel document. Okay, usually it's around the 6 months after you file your adjustment of status case. So I hope that answered the question. And thank you very much for that question. Okay. Again, if you do want to reach out to us for a specific consultation, then just feel free to reach out. We'd love to talk to you. Okay. Okay, this is another question about advanced parole, about a travel document. The question is, I'm on DACA and I want to ask for advanced parole. I'm not really sure my reason is good enough. Can you help me? So, when you're in DACA, and DACA stands for Deferred Action for Childhood Arrivals, if you have this specific um, situation, this is your status here in the United States, and you want to travel, you can. You can ask for a travel permit if you meet certain reasons or requirements. So you can't ask for a travel permit just for any reason. You have to have a specific reason. If you're on DACA, you have to have a specific reason for travel. And it's usually either humanitarian, financial, educational reason, okay? And there's a lot of benefits for traveling on DACA. Okay, I'm really encouraging that right now. And I've done videos about that. Last week we talked about it. Someone asked a question. It's really good for you if you are a DACA that you travel out of the country and come back in, because most time a lot of people on DACA don't have a legal entry. And if you come back in on advanced parole, you're paroled in, you do get that legal entry, and that could make a process later a lot easier. So I always recommend doing that. If you're not sure about your reason, if it's strong enough to get an advanced parole approved, reach out to us. We'd love to talk to you. It's really about presenting the case, the situation in a creative way. I can give an example of a case that we had where we had a client that wanted to go visit his grandparent, but the grandparent was relatively healthy. They didn't have any serious medical conditions. They were older, as grandparents tend to be, and they had all kinds of conditions. High blood pressure or diabetes, or not 100%, like someone that was maybe younger would be. And they were also worried, like, is this enough? Does my family member need to be really ill? Like, seriously, does this need to be a life or death situation? We were able to get his advance parole approved because we basically told immigration, look, it's true, my family member is not dying, right? They're not, knock on wood, they're still okay, but they have a lot of conditions going on. And I want to be able to spend time with my family member before they deteriorate, before they get to a stage maybe that they won't be able to spend quality time with me. So even if you're not sure that the reason is enough, then definitely consult with an attorney so that an attorney can help you draft the perfect advance parole request, okay? And really create a story that would be persuasive, okay? Not create a story, but show your case in a persuasive way. Okay, perfect. For those of you guys joining us, or for anyone watching the recording of this afterwards, please feel free to write your comments, your questions in the comments. I'm happy to answer them when I see them. And if you're watching the recording, I promise to get to them as I see them. Okay, perfect. Let's pick another question here. Okay. I'm a green card holder for more than 5 years. Should I apply to become a citizen? How hard is it? Okay. So anyone that is a green card holder for 5 years generally would be eligible. However, you need to make sure that you meet all the requirements, right? Having a green card for at least 5 years is one of the requirements, but it's not all of them. Okay, you have to show that you have not taken any extended trips, so you've been continuously residing here and physically present here in the United States. You have to show that you are a person of good moral character. You need to show that you have complied with all the rules in the last 5 years, the moral character aspect of it. So there are other requirements. Okay, so if you have been a green card holder for more than 5 years, I definitely recommend to reach out, have a consultation to evaluate if you are eligible or not. We offer a free evaluation for naturalization citizenship cases, so please reach out to us and call us. We'd love to just have a conversation, make sure that you're eligible, and then tell you about the process. How hard is it? I don't think in a naturalization case is hard. A lot of people are a little bit nervous because there is a test involved. It doesn't matter how old you are. When we hear a test, it makes everyone a little bit nervous. But the test is not a surprise test. It's not a tricky test. It's basically you have to memorize some information, some questions, and if you memorize, if you practice, then definitely you have a great chance to getting naturalized. And I definitely recommend it. Okay. So reach out. We'll do a screening for you and we'll tell you if you're eligible. Okay, let me see. I see here there's a question on YouTube. Hanio is asking, I entered twice in the USA, first with a tourist visa, and I overstayed for 12 years, and second time I crossed the border without inspection, 10 years already. Now I have a son who's in the Marines. Any chances to adjust my status? Okay. Where are you from originally? What country are you from? So I definitely recommend, Hanio, to have a consultation um, and review your case specifically. There is a law that says that if you've been in the United States, generally speaking, if you've been in the United States for more than 1 year unlawfully, and then you leave and then you enter back in unlawfully, you would be subject to a 10-year bar. Oh, you're from Brazil. Okay. That you would be subject to a 10-year bar to return, which is unfortunately a permanent bar. So having a son in the Marines would not cure the permanent bar, but I would definitely ask you to reach out, have a consultation to see if there's anything else that we can see in your case, anything that might meet that, any exceptions to the general law. Okay. The laws regarding multiple entries to the United States and entering, overstaying, and then re-entering unlawfully are pretty strict. But sometimes there are some exceptions, and sometimes there are ways where you can overcome that and surpass that. Okay. Okay, perfect. Let me jump into a next question. I have a 2-year green card, but my wife is now asking for a divorce. What should I do? Okay, so for those of you that don't know, if you are applying for a green card based on marriage and your marriage is less than 2 years old, then you will receive something called a conditional green card, meaning your green card will only be valid for 2 years. Okay. And before the 2 years, you have to file another petition to get the permanent green card, to get the 10-year green card. And that petition is a removal of conditions petition. So generally, right, you have to file it jointly with your petitioner, with your wife, right? However, immigration is not going to make anyone stay in a relationship that is not that they don't want to stay in just for the removal of conditions process. So if you are facing divorce, then you can still apply to remove the conditions of your green card, and you can do that by yourself. You can do that through a process of a waiver of the joint filing based on your divorce. This is a little bit more complicated, a little bit more of a complex of a process, but it is possible. Okay, so don't worry if you are going to go through a divorce. It doesn't mean that your green card is gone. There's a waiver you can ask, a waiver of the joint filing, and it's possible. Okay, we would love to help you. Reach out to us and we can give you more advice. Okay, perfect. How's everyone doing? If you have any questions, feel free to write them in the comments. If you're new here, please like our channel and follow us as well, so that we can give you more information and notifications about updates with immigration. Perfect. I'm going to answer some more questions, and if you have any, just let me know. Okay, there's another question about the removal of conditions. It's a hot topic today. Again, remember, removal of conditions is the process of applying for the 10-year green card. Okay, so if you have a 2-year green card, you only got a conditional one, you can ask you have to apply to remove the conditions on your green card, and you do that through a specific petition. So what documents are required when you're filing for removal of condition? So in general, what you need to show is that if you are filing jointly with your spouse, with your petitioning spouse, you want to show that you have been together, that you're, ever since you got your green card, you are still living together. So you really want to show joint documents, and you want to show it from the day that you received your green card and on. So you don't want to go back to show documents that you presented in your first case, in your first green card. Now you want to look at the date you got your green card and then present documents from that date on. You can show tax returns, bank statements, insurance policies, anything that you can think of, affidavits from friends and family attesting to your relationship. Okay, if you've taken any trips, if you have any children born, that's really great. That's my favorite kind of evidence. Anything like that would be really good for the removal of conditions. Okay, perfect. Okay, jumping on to the next one. Okay, I received a request for evidence on my adjustment of status. What do I need to do? Perfect. So again, adjustment of status, just a fancy word, just it means a green card application, right, in the US. So if you received a request for evidence, that means that immigration, USCIS, cannot approve your case or cannot make a decision on their case because they are missing evidence. They need more documents, they need more information. And what you should do is you should read carefully the request for evidence. And first of all, look at the first thing I always look at is what is the deadline? When do I need to respond by? Usually it's 90 days, but sometimes it could be 30 days. So make sure you know what the date is and calendar that date, because if you don't respond, if you're late to respond, then they will actually deny your case because you failed to respond. Okay, so definitely the first thing I do, I check at the date, I see when do I need to respond by. The second thing I do when I see a request for evidence, I read it really well. And I ask and I mark, with a highlighter, what is it that they want? What is the reason that immigration is asking for more evidence? It could be as simple as that they need me to submit a medical examination because you didn't submit them with your original application. That's one of the most common requests for evidence, is a request for evidence for the medical examination. So they will have an explanation of how you do it, what you need to do. It could be that they're missing some information. They're missing a document. They're missing a birth certificate, a marriage certificate, or something like that. Or it could be that they are missing proof of your relationship, proof of your legal entry, or things like that. If you receive a request for evidence, it's super important to make sure you understand what they want. And I always recommend to consult with an attorney because this is most likely your last chance that you can get your case approved. Okay, if you do not submit the request for evidence, or you do not submit at all, if you don't submit it properly back, then they will deny your case. Okay, so if you're not sure what's needed, you're not sure where you need to send it, you're not sure about this request for evidence, reach out to a professional to help you. Okay, but so that's what you need to do in general. I don't know specifically what's on this adjustment of this request for evidence, but follow the directions and you should be fine. Perfect. Okay, guys, I'm gonna do a couple more questions today. Let's see. Okay, I have a case pending with the NVC, the National Visa Center. I am now in the US, and due to the situation in my country, prefer to stay in the US. Can I transfer my case? Okay, so if you had a case pending with the National Visa Center and then you came to the US, I'm assuming you came in on some kind of non-immigrant status, right? Either an ESTA or a tourist or something like that, and you came for a temporary visit, but then you decided that you do not want to return to your home country, you want to do the process here. You can transfer your case. Generally speaking, the process would be to notify the National Visa Center that you're now here. and you want to change the process. You want to file for adjustment of status. So to do this, you need to be here legally. Okay, you have to be here legally with being inspected and admitted at the border. So come in with a visa, and then you have to have a visa available for you. So, for example, if you're married to a U.S. citizen and you filed your case originally in your home country, you came in as a tourist, then generally speaking, you can apply for the green card here. But if you have a case that's pending with the National Visa Center, but it's not your spouse, it's your brother or sister, and the priority date is not current, you will not be able to apply for it here. So this is tricky stuff. I really recommend in this situation to reach out to a professional to get advice about your case. But generally speaking, it might be possible. You might be able to do it if you meet certain requirements. Okay, perfect. Yes. Yes, you can still ask me a question. Kawaja, yes, please ask me a question. Why don't you type it in? Try to write as much details as you can. Tell me where you're from and what's your question. Okay. In the meantime, I'm gonna go to another question while you're typing. Okay. Okay. I have a pending. Oh, I did that one question. Let's do this one. Okay. Can you explain about VAWA? How do I know if I'm eligible? Okay. If you're following me, you know that I talk a lot about VAWA. I'm very passionate about this case type. I think not a lot of people know about it. So anytime there's a question about VAWA, I'm going to bring it up. VAWA stands for Violence Against Women's Act. It's a humanitarian option to apply for your green card here in the United States by yourself, for yourself. So it's a self-petition. Okay, it applies to men and it applies to women the same way, even though it says the word women in the word. Okay, and basically, this is a law that says that if you are in a relationship with a U.S. citizen, so U.S. citizen spouse or lawful permanent spouse or green card holder spouse or a U.S. citizen child over 21, and that relationship is not good, meaning that relationship is not healthy, you are suffering in that relationship from cruelty, from psychological abuse, mental abuse, financial abuse, physical abuse, but that's not required, then you can ask for a green card on that basis, on the basis of being in an abusive and cruel relationship. Okay. You do not need to file a police report. There's no requirement to cooperate with the police or to even inform your family member that you're doing this. This is a completely 100% confidential process. It's a way for you to get your green card in the United States without leaving. It's a very generous option. So it forgives a lot of things. It forgives coming in unlawfully to the country. It forgives working without authorization. Okay. It can forgive a lot of things. So, and forgives, having to go back to your country for the process, right? It could forgive the 10-year bar. So if this is your situation, if you think that you might qualify, please reach out to us. We'd love to help you and screen for this case type. Okay. You'll know if you're eligible. First of all, if you have a qualifying relationship. So if you have to be either married to a U.S. citizen or a resident or have a 21-year-old child that's a U.S. citizen. That's the first thing. Now, even if you are no longer married, as long as you have not been divorced for more than 2 years, you can still qualify for this. Okay. Perfect. Kawaja, did you want to ask me a question? If you do, I am more than happy to answer it. If you guys are watching this as a recording, then you can still write a question in the comments. I see it. We do get a notification, so I will see your question. It might take me a while to get back to it because I don't see it always right away, but I will go back to it and answer your questions even later, okay? Okay, let's see. A deported person may be eligible again for comeback again if facing overstays charges in the past and also married with a U.S. citizen in the past, but the case was denied because of our stay charges in 2006. Also married here. Okay. Someone that was deported before might be able to come back, right? For example, if they spent enough time outside the country, or if they didn't spend enough time but they want to come back early, they can ask for a special forgiveness and a special approval to come back early. Being married to a U.S. citizen is a great step, but it doesn't always help. It doesn't always get you through the finish line with the green card. So my recommendation is to reach out to us specifically. Let's have a consultation. Our number is here on the screen if you see it. Let's have a consultation and discuss your case specifically. Okay? I'd love to talk to you and see if I can help you. Wonderful, guys. Well, I hope that was helpful. Thank you so much for everyone joining. I'll be here next week it's actually Thanksgiving, so I might do it a little bit early. I might do it on the Wednesday instead of the Thursday. So until next week, everyone have a safe weekend. And I wish you guys all the best, good health and safety and peace. And I will see you here very soon. Thanks, everyone.